Okay, looks like people are still filtering in, but we've got a lot to cover today, as always. So we'll go ahead and get started. Our presentation this month is about exempt or non-exempt employees. And we're going to talk a lot about exempt employees and their classifications today. But we'll also be talking about why that classification it is so important to get right. Um, I'm Janelle Stanton. A lot of you have been in our presentations before and know who I am. If you've not been to one of my presentations before, I'll just quickly say about myself. I am a management side labor and employment attorney. I do employment litigation and corporate law here at Wagner, Falconer, and Judd, and love to get to do these presentations and educate our clients on all of the various compliance headaches that employers are having to face every day. And exempt and non-exempt employees is certainly a big area. So the reason that obviously we're here and we're talking about this is because if you are improperly classifying employees as exempt, these lawsuits can become extremely expensive very quickly. And I'll just kind of briefly talk about why that is. So if you have an employee that you classify as exempt, you are not paying that particular individual overtime. And that's because that particular person, if they are classified as exempt and properly classified, they're going to be earning a salary. So they're not eligible for overtime pay. Well, if you've misclassified an employee as exempt, you've not been paying overtime. And let's say you've had, 25 employees in this exempt category for years. And maybe these people work a whole lot of hours, but you've not been paying overtime. If one of these employees brings a lawsuit, you can be subject to a class or collective action where all of the employees in that particular group bring a lawsuit at the same time against your company. And what they're going to allege is that for the last 2 or up to 3 years, depending on the circumstances, of unpaid overtime is owed to the employees, plus attorney's fees, plus other, there could be liquidated damages penalties where basically the amount of money that you owe to the employee is doubled. So these can get extremely expensive. So being sure that you understand that what the exempt classifications are and that all of your exempt employees are properly classified is extremely, extremely important. So just by way of a couple of definitions, so what we're talking about is exempt versus non-exempt. We're not talking about salary versus hourly. A lot of people use the term salary as though that is exempt. And that's not truly the case because we can pay non-exempt employees a salary. So we're not talking salary versus hourly, though exempt employees do have to be paid on a salary basis, and non-exempt employees are typically paid on an hourly basis. But the terminology is exempt versus non-exempt. So that's really key to get used to that type of, or used to those terms instead of salary versus hourly. So non-exempt employees. So again, typically these are hourly employees. Non-exempt employees, for those individuals, you've got to meet all of the minimum wage and overtime requirements that are spelled out by the Fair Labor Standards Act and other applicable state laws. This also means you need to be tracking non-exempt employees' time, paying them for all hours that they are either suffered or permitted to work. So when you've got non-exempt employees, there's a lot of timekeeping and tracking requirements because you have to make sure that you pay the applicable minimum wage and overtime which is, of course, generally time and a half for any hours worked over 40. Though I will throw in a quick caveat here that some states have different overtime requirements. Most notoriously California, if you work over a certain amount of hours in a day, if you work more than a certain amount of days in a week, you are subject to different overtime requirements for non-exempt employees in those states. So make sure you're aware of that. So that's your non-exempt employees. And then exempt employees are typically not covered by the minimum wage or overtime requirements, though there are some exemptions where they are eligible for certain, minimum wage, but not overtime, or overtime, but not minimum wage. So just note that generally, when we're talking about the administrative, managerial, and professional exemptions, those folks are not subject to minimum wage and overtime requirements of the Fair Labor Standards Act. So in order to be an exempt employee, there's a three-part test that has to be met. So the first is that they have to be paid on a salary basis. They've got to be paid at least a specific amount of salary, and they've got to meet the relevant duties test. And we'll get into all of these particular components here. But the most important thing that you need to remember is that all employees are born non-exempt. That's a saying. They're born non-exempt. So that means you've always should be deferring to paying employees overtime for all hours worked over 40, that you should be paying minimum wage. Most non-management positions, construction, production line workers, mechanics, janitors, wait staff, file clerks, first responders, EMTs, etc. These are all non-exempt positions. And if you sort of start with this number one principle that everybody's non-exempt, unless you can fit them into an exemption, that will take you a really, really long way and get you mostly compliant. But of course, it is beneficial to companies for a lot of reasons to classify employees as exempt. You just need to do it properly. So what do you need to do to classify an employee as exempt? So like I said, there's a salary basis and a salary level test. So first of all, an employee has to be paid on a salary basis. So that means they have to receive the same amount of pay, whether they work 4 hours in a week or whether they work 50 hours in a week. So that salary cannot fluctuate based on the quantity of work. It also can't fluctuate based on the quality of work. So that is how that is defined. It's got to be a pre-established salary. This is also important because you cannot make improper deductions from the salary. So one of the biggest examples is, let's say you have an exempt employee work a half day because they are sick, for example, and you've got a paid sick leave policy, and you cannot make deductions from an exempt employee's pay for partial days that they miss that are related to personal reasons or for sickness or illness. So you have to be very aware of what those improper deductions are and avoid making any of those improper deductions. There's also a specific salary threshold. So that salary threshold, it's a predetermined salary of at least $684 per week, which factors to be out or works out to be something around, I think it's like $33,000 per year, something like that. But we'll talk a little bit more about the salary threshold in just a moment. And then they also have to meet the duties test. So again, 3 parts here. The duties test, so there's They have to meet the relevant duties and perform the relevant duties of these positions uh, to a certain extent. So of course, almost all exempt employees perform some non-exempt work, but their primary position or the primary purpose their job exists has to fit within one of these uh, exempt statuses: administrative, executive, professional, highly compensated employees, computer professionals, outside sales, commission retail sales. So, and just so you know, there are state law differences here where the administrative test, the administrative exemption test, can differ from some states. So we'll get more into that. So the salary level, like I said, it has to reach a certain threshold, and that is currently $684 per week or $35,568 annually. If you recall, and we've talked about this before, back in 2016, the Department of Labor had issued a new rule which would have raised the salary level up to $913 per week or $47,476 annually. That was struck down by a federal court judge in the Eastern District of Texas just 10 days before that rule was set to take effect, which really threw a wrench in a lot of people's plans because people had prepared for a long time for this new rule to come out. So that got struck down. Now, recently, at the end of August, there was introduced a new rule to potentially raise the minimum wage or raise the salary up to, I believe it's $1,059 per week or something right around, it's like 56,000 or something like that. So there is a proposal out there that would increase this salary threshold across the country. It's very tenuous because there are already groups that are saying that they're going to go ahead and challenge this. I suspect they'd probably go back to the same jurisdiction in Texas to challenge it. A challenge has previously been successful there. So it remains to be seen whether this will get increased or not, but something to definitely keep your eyes on. And I also pointed out already, there are state law differences. So by way of example, in California, as of January 1st, 2023, employers had to pay a salary of at least $1,240 per week in order for an individual to be properly classified as exempt. Colorado has different amounts, Maine has different amounts, New York has different amounts. So just be aware that there can be state law differences, and where the state law provides for provides a statute that is more employee friendly than the federal law, the state law is going to apply in that context. So be aware that you may need to look at those states where you have employees working. I already touched on this, like I said, the salary basis test. So you've got to be careful that you're not making improper deductions. Most people don't get tripped up here on paying the salary. That's usually not the problem. Most people pay the salary. Usually the issue becomes that if you make improper deductions, the risk is that you're no longer paying on a salary basis and you lose the exemption for that particular employee for that period of time that you're making improper deductions. So you've got to be really careful to not like take deductions when an exempt employee misses a partial day, for example. All right, so I think the other two components of the exempt employee test are fairly straightforward. There's not a lot of room for error. The really difficult part and the challenge for employers becomes the duties test. And I would say this is the most important part of the test because it's so fact specific. And you really have to look at the particular job duties that that employee is doing every single day. I've got some points throughout that I'll illustrate that primary duty component and how critical it actually is. But when we're looking at the job duties of a particular person and not just the job description, like I said, the actual job duties that they're performing, we're looking at what is the principal, main, major, most important reason that that job exists. And as long as they're performing exempt duties at least 50% or more of their working time, then it's likely that that person is properly classified as exempt. 50% is the lowest amount that you can say, that you can safely do. If you can ratchet that up and not have exempt employees performing any more than 20% of their time, spending more than 20% of their time doing non-exempt work, that's better if you can do an 80-20, not 50-50. But again, so the bare minimum is they have to be performing exempt duties 50% or more of their working time. Right. So I'm going to cover in detail the three main what are called white collar exemptions. And then I will talk briefly on some of the other sort of tangential exemptions as well. One of the most frequently used exemptions or claimed exemptions is the administrative exemption. So for an administrative employee to be properly classified as exempt, they have to meet their position and the job duties that they perform has to meet both of these factors. So they have to perform office or non-manual work that is directly related to the management or general business operations of the company. They also have to be able to exercise discretion and independent judgment regarding significant business decisions. So let's get into some of the nitty-gritty here, because while the test sounds clear-cut, whether an administrative employee exercises independent judgment and discretion is really the crux of most wage and hour litigation. So an area where people are very frequently misclassified is administrative assistants, right? It's the administrative exemption. So it sounds like administrative assistants would naturally fit within this exemption. However, a lot of times what an administrative assistant is doing is they're using prescribed instructions or prescribed processes for performing their job. They're not exercising discretion. They're doing things the way that they've been instructed or the way that they've been done for years. They're not actually exercising discretion. And they're certainly not exercising discretion as it relates to significant business decisions. So to break this down a little bit more, what does it mean to be directly related to the management of the business? These are administrative professionals who work in a functional area like tax, finance, accounting, purchasing, procurement, advertising, marketing, personnel management, HR, labor relations, things like that, similar activities where it relates to actually getting the work done. When you're looking at whether they have the ability to exercise discretion and independent judgment, you're looking at, does the employee have the ability to formulate, affect, interpret, or implement management policies, operating policies? Can they carry out major assignments for the company with very little oversight or direction? Does the work that they're doing affect the business operations to a substantial degree? Do they have the authority to commit the employer to things that might have a significant financial impact? Or does the employee have the authority to waive or deviate from established policies and procedures without any approval? These are things to think about as to whether they're able to actually exercise discretion and independent judgment. I would say that it's the rare case where a receptionist or where an administrative professional is actually exercising that discretion. Certainly can happen, but it is worth noting that you should be auditing your job descriptions and looking at what these folks are actually doing every day. And if 80% of or what they're doing is prescriptive, if they're just following a rubric, if they're just following established protocol for how to get their job done, then they don't meet this second prong and are unlikely to be classified properly as exempt. Another example here that I wanted to bring up to point out is the difference between, and this is how nuanced these issues become. So if we look at like a bookkeeper versus an accountant, like a CPA, the bookkeeper, maybe somebody that handles delinquent accounts according to specific standards established by the company, that person is likely non-exempt and needs to be paid hourly for all hours worked, paid overtime, all of that. Accountants, CPAs, for example, that have specialized training where they're able to use judgment and discretion, those folks are likely exempt. Now, not all CPAs are by themselves exempt under the administrative exemption example. They may be exempt as professionals, but we'll talk about that in a little bit here. But I just want to point this out because it underscores the necessity of looking at what each person is doing in a day. And certainly titles, job descriptions, those are not sufficient to justify exempt classification here. All right, so moving on to talk about the executive exemption. This one is a little bit easier, I think, because the three factors that you have to look at for whether somebody is properly classified as under the executive exemption, they're a lot more clear than the administrative exemption. Now, the problem becomes here considering any manager to be exempt. This is a huge mistake, and I'll give an example in just a couple of slides to help you kind of understand what the problems can become. So here you have to have the primary duty is managing the full enterprise or a particular department. The individual has to be customarily and regularly directing the work of at least 2 or more full-time employees, and they have to have the discretion to hire or fire employees, or if they give their recommendation about hiring and firing, those recommendations are given a significant amount of weight. So primary duty is management. This is things like interviewing, selecting, and training employees, adjusting rates of pay or work hours, planning and directing work tasks, maintaining documents used for performance evaluations, doing interviews, dealing with workplace complaints or grievances, making budgetary decisions or having oversight of the budget, monitoring and implementing legal compliance measures, ensuring employee safety. These are all things that are the primary duty being management. These are things that would highlight that. Now, I'll share that when I was in law school, I worked for a large nationwide retailer, and I worked as a manager and was classified as exempt. And the majority of the work that I did was not exempt in nature. And retail management is one of those areas where employers can get themselves in a whole lot of trouble. Um, for example, I think this was back in 2015, 2016. There was a case in the 11th Circuit. The 11th Circuit is Alabama, Georgia, Florida. And there was a store manager who was, they were working for, again, a nationwide retailer. And the the employees who were classified as exempt under the executive exemption claimed that they spent 80 to 90% of their time performing non-managerial duties like stocking shelves, unloading delivery trucks. They also were cleaning bathrooms and doing lots of other tasks. But essentially, after going through a trial and going through all of that rigmarole, the company ended up paying a settlement of $35 million. $35 million because they had improperly classified a whole host of retail managers as exempt under this exemption. And those folks did a lot of other work. So while retail managers might technically on paper be managing a team, you do have to look at what they're doing. And sometimes retail is just really staffed leanly. You might be operating on a skeleton crew to be efficient, for cost saving measures. I mean, often as a manager in a retail space, there just isn't a lot of day-to-day management that's needing to take place, and really you needing to run the register and, hold close and things like that. So you have to watch out. This is another one that you've got to be careful of, because these settlements, depending on how many employees you have classified improperly, these can get very, very expensive very quickly. All right, so the professional exemption. So somebody has asked me if I can talk about the creative professionals exemption. So yes, I will definitely be touching on that. So there's also another exemption for professional employees. So, and again, this is another 3-factor test. So here, the primary duty has to be performing work that requires advanced knowledge. And that means it's work that's predominantly intellectual in character, and that includes requiring the consistent exercise of discretion and judgment. So that means professional work is distinguished from work that involves routine, mental, manual, mechanical, or physical work. So it's got to be intellectual work. And generally, a professional employee uses advanced knowledge to analyze, interpret, or make deductions from varying facts or circumstances. Usually, the advanced field must be in a field of science or learning, though advanced knowledge can be obtained at the high school level. A college degree is not required, but usually the knowledge is acquired by lengthy, specialized intellectual instruction. So some of the areas where, some of the areas that are professionals, lawyers. As a lawyer, I'm an exempt individual, and probably a good thing for my employer. But folks in medicine, doctors, accounting, actuarial science, engineering, architecture, teachers, pharmacy occupations, those are individuals that are typically professional or qualified for the professional exemption. Like I said, teachers are exempt if their primary duty is teaching, tutoring, instruction, or lecturing in the activity of imparting knowledge. There can be non-exempt teachers though as well, but usually they are exempt. And then, so you have learned professionals, like we've just been talking about. You also have an exemption for creative professionals. So a creative professional is one where the employees primary duty involves or requires invention, imagination, originality, or talent in a recognized field of artistic or creative endeavor. So actors, musicians, composers, painters, writers, cartoonists, essayists, novelists, those are individuals that can fit within that creative professionals rubric. So again, just to illustrate some of the nuance here, I did point out engineers, and many engineers are properly classified as exempt under the professional exemption. Certified engineers, for example, are almost always going to be exempt learned professionals. But there are other folks who either maybe are working in an engineering firm or have some kind of other engineering skill set, but where the specialized knowledge is more as a skilled technician rather than an engineer, that like a design specialist, as an example, that particular individual is likely to be non-exempt if the role doesn't require an advanced degree, but rather you can get the skill needed to do the job through work experience. So again, just good to keep in mind. Another one that I'm very frequently working on with clients and helping them to figure out are project managers. Project manager, that's a tough one. And depending on what that particular project manager is doing, they can fall in one of two, they can fall in either camp. Some are exempt, some are non-exempt. So some of the other exemptions that that are out there are the computer related professionals. So in order to qualify for the computer employee exemption, an individual has to be compensated on a salary or fee basis. So they have to make the 684 per week. They have to be employed as a computer systems analyst, computer programmer, software engineer, or other similarly skilled worker in the computer field. There's also they have to, their primary duty has to consist of a few things: the application of systems analysis techniques and procedures, or the design, development, documentation, analysis, creation of computer systems or programs. They have to be designing some kind of computer program related to machine operating systems or a combination of the above. So it does not include individuals who are repairing computers or hardware, and it really is highly dependent on what your related skill is and what your are you just again performing routine procedures, or are you using your creativity, using your analysis and your testing techniques and things like that to meet this particular exemption? Like I said, the educational establishments and administrative professionals, there might be different exemptions there. Another one that is used a lot, and I think probably used improperly, is the outside sales exemption. In order to qualify for the outside sales exemption, the employee's primary duty has to be making sales where they are customarily and regularly engaged away from the employer's place of business. So they have to actually be going out there, knocking on doors. They need to be going to hospitals and meeting with doctors if they're a pharmaceutical sales rep. They have to be going out and meeting with client and obtaining those purchase orders and outside of your workplace. And this doesn't mean working from home. This means actually any fixed site is not going to qualify. They have to be going like door to door almost and going outside. Outside sales does not include sales made by mail, telephone, or internet, only if those are adjunct to, the sales activity. So they really have to be going out there and obtaining those purchase orders outside of your work in order for that to qualify. And I believe, and I'm looking here at my notes, I believe that it has to be 80% of their time is spent away from the employer's place of business. Another one to discuss too is highly compensated workers. The regulations have a special rule for highly compensated employees. Currently, that is set at, I believe it's $107,000 per year. Highly compensated employees can be exempt if their total annual compensation is $107,000 or more. The employee's primary duty includes performing office or non-manual work, and the employee customarily and regularly performs at least one of the exempt duties or responsibilities of an exempt executive, administrative, or professional employee. So if they're very highly compensated and they are training employees, new hires, if they're responsible for doing that training, in that situation, those folks can be exempt as a highly compensated employee. Oh, here's a question. So for exempt employees taking a full day off or days off and they don't have enough PTO to cover, how is that applied? So if they're taking a full day off, but so again, you have to pay exempt employees for if they work any hours in a work week, they have to be paid their full salary. So if they don't have enough PTO to cover it, you should not be taking deductions from pay in most instances, but you can treat that as a disciplinary issue because if they're already out of PTO and they're taking lots of time off and they don't have enough to cover it, if they perform work in that work week, they have to be paid their full salary. I pointed this out a little bit, but I guess I wanted to just touch on this a little bit more heavily because I think it's really important to be aware of state differences. There's also can be differences like industry specific exemptions. A lot of agricultural workers have their own exemptions that differ from these white collar exemptions that we've been talking about. So there can be others outside of what we've discussed that apply to your employees and you need to be aware of. Cities and counties can also have their own ordinances. And as I mentioned at the beginning, if a state, city, or county law is more friendly than the federal rule, then the state or local law is going to apply. It's going to overrule the federal law. And if we think about it, in the terms of exempt or non-exempt, it is more employee friendly to be non-exempt because you get paid for all the hours you work, you're eligible for overtime, you're guaranteed at least minimum wage. So typically, if the state is less favorable to a particular exemption, then it's not going to apply. So for example, Minnesota does not recognize the computer professional or the highly compensated employee exemptions. So because Minnesota law does not recognize those do not apply to Minnesota employees. Like I said, there's also those industry specific exemptions that you need to be aware of. I already pointed out California salary level test. California also makes it very difficult. They have their own white collar exemption tests that are very different and much harder to meet than what the federal exemptions are. So some of the most common pitfalls I see, and then we'll get into talking about how to address this. So always classifying salaried employees as exempt. And I think this comes down to that thing that I was talking about at the very beginning of the presentation, where there's this misconception that it's salaried versus hourly employees. Well, it's not. I mean, sure it is, but what we're really talking about here is exempt and non-exempt. It is possible that a salaried employee could be non-exempt and must be classified as non-exempt based on the job duties that they're performing. So if you always classify salaried employees as exempt, that can be extremely problematic. Always classifying supervisors as exempt. We've already talked about that. Classifying employees based on job descriptions or titles. This is, again, this is where, for example, the project manager example that I brought up earlier. Some project managers might very well be exempt employees. Others might not. So you cannot rely on job descriptions or titles. And so you may need to go look at what that employee is doing. You may need to do a full audit, and I'll talk about those audits. The other really common pitfall is making those deductions from exempt employees' paychecks that are improper. So how do you stay on the right side of the law here? So the biggest thing to do, and what I can't recommend enough, is to do a wage and hour audit of all of your exempt positions. And you need to look at what are the actual tasks that that person carries out in a day. So you might need to sit down with your employees or their manager and get a sense for what job duties are actually being performed to make sure that at least 50% threshold of exempt work is met. And if they don't, or the employee's work has changed, you may need to possibly consider reclassifying that individual as non-exempt. Now, this is dangerous territory when you reclassify somebody from exempt to non-exempt, because they might start to ask questions and wonder, well, wait a minute, I've been exempt for the last 5 years. Now you're saying I'm not. Why? And so this can be really problematic and can open up a can of worms for you. So how to handle this is going to be really dependent on the facts of the situation. How many employees do you have improperly classified? Is there a way that you can go back and determine whether in the last 2 years this individual worked any overtime? And if so, can you pay them and make them whole and make it right for them so that they don't bring a wage and hour lawsuit against you? For some employers, that makes sense. For others, that might be an extreme financial burden. But the reality is, if you have an improperly classified person, they either need to be reclassified, or maybe they have taken on new job duties that push them into that realm of being exempt. And so maybe you need to update the job description to reflect what duties that employee performs. Maybe you need to give that individual more leeway, more flexibility, more autonomy to do their job, because they have experience. And maybe that's enough to push them into the administrative exemption, for example, if you're going to start giving them that ability to exercise independent discretion and make their own decisions. So there's a lot of ways that you can remedy this situation. It's just you do have to be extremely cautious when doing so, because if you've got improperly classified folks, somebody gets upset about being reclassified because some people they do get upset. There's a sort of idea that exempt employees are higher level employees, that it's a position of trust, that you don't have to track your hours. It can, for some folks, being reclassified as non-exempt gives them a lot of heartache, a lot of heartburn. They don't like it. They don't want to go back to tracking their hours. They like the stability of a salary. So it can be a tough sell, but it's much more expensive to not deal with improperly classified employees than it is to fix it. So you've got to go ahead, you've got to fix it, you've got to make things right. And this is where messaging becomes incredibly important. So, messaging that, this is part of a whole overhaul that the company is doing to make sure that everything is above board. You've done a whole analysis of all the positions in your workplace. And now these employees, yes, you have to track your time, but now you're eligible for overtime. We know how hard you work. There's ways that this conversation can be massaged so that it is not a net negative to that employee. So again, whether you go back and make it right, make the employee whole, that all depends. So again, if you have employees that are improperly classified as exempt, but they've never worked a stitch of overtime in their life, well, maybe it's not the worst, it's not the worst situation. The bigger problems become if you've got somebody who's improperly classified and they're just killing it. They're working a lot. They've got a lot of overtime. And if that person goes out and sues you, you're going to be paying 2 up to 3 years of past due overtime, possibly multiplying that number by 2 for a liquidated damages penalty, possibly multiplying that number by any other people in that same classification that are misclassified. So I don't mean to scare you, but this is really critical and something that employers need to be thinking about and looking into with a magnifying glass. Um, I'll just sort of do one quick little pitch here, and I'll say that if you can do these audits under attorney-client privilege, that is a gold standard, because if you come up with issues where there are misclassifications and there are things that you need to fix, if that is done under the attorney-client privilege protection, then if there is a subsequent lawsuit, the outcome and the determinations may be able to be protected from discovery. So I've got another question here, and I did want to put Chris's information up here. If you have questions, if you want an audit, or looking for something like that, reach out to Chris Kelly at Asset HR to get more information. I do have a couple questions here I'm going to take a look at. Kathy asks, how do you handle employees who have multiple roles in small companies? Do you just consider primary as a percentage of time doing the higher level? So again, it's all going to come down to job duties. And this is extremely common in a small business where we're all wearing lots of hats. You're going to need to look at what are the percentage breakdown of time. So you need to probably talk to that individual and get a sense for how are they spending the majority of their day. And it's possible that some of these exemptions can sort of straddle the line where maybe one of that person's roles, they're administratively exempt, one of that person's roles, they're exempt as a professional. So you do need to look at the percentage of time and make sure that they're performing at least 50% of their daily tasks, that at least 50% of those are exempt tasks. I'm just reading these other questions here. I've got a question here about an employee returning from disability leave. This is a really complex question. So if you are already part of the compliance center, if you have the service, I would definitely suggest reaching out to Chris and getting either getting signed up for the compliance center or getting in touch with us through Chris, because this is a extremely complicated question. So please do reach out to us if you are the asker of that question. Let me just check the other Q&As here. So this creative professional exemption, proofreaders. Could proofreaders be a creative professional? Yes. It depends on what kind of proofreader they are. So if we think about, there's different levels of this. So if we think about somebody who is an editor, a book editor, that editor is not just saying semicolon, this is a colon situation. They are going through and they're saying, this really doesn't make sense in the context of these other chapters. This character really should have, this character probably should have done this and not that. If it's in keeping with the flow of the story, things like that. So somebody who's in an editor capacity might very well fit within this creative professional exemption. But somebody who's proofreading, who's taking, like us lawyers, we have to comply with the formatting rules of the Blue Book, for example. If somebody's just taking the Blue Book and checking citations and making sure that there's not an extra space or there is an extra space or this is in italics and that is not, I would say that that individual is unlikely to be a creative professional because they are not using those creative juices to do their job. They're using a really strict rubric to, modify citations or, like I said, add a comment or a comma or, correct a misspelling. I would say it's less likely that those are a creative professional exempt position. Does anybody else have other questions that they want to ask? I'm not seeing anything else come through, but I'll give it just a few moments here. All right. Well, if there are no additional questions, I just want to take a second, thank everybody so much for attending today. We have more webinars coming up in our webinar series, so I hope you can join us and have a great rest of the day.